Hello Year 12s, and welcome to this video in which we look at one of the factors that affects the ability of the courts to make law, which is the doctrine or rules of precedent. In preparation for this video, you should already have watched the precedent refresher video. As you watch this video, there are three things that you need to do. First, take the very best Cornell notes that you can. Second, use the pause and rewind functions. Use the pause function if you need to stop this video to take notes. Use the rewind function if you need to go over any information contained in this video. And the third thing that you need to do is have your summary books open in front of you. As we go through this video, I will give you some guidance as to what you should write in your summary books. Once you've finished watching and taking notes on this video, please read the pages from the textbook referred to on this slide. And if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that additional information. Well, let's get started then. This is the first in a series of 3 videos about the factors that affect the ability of the courts to make law. I've listed the factors that we'll be looking at in these 3 videos on this slide. In this video, we'll be looking at the doctrine or rules of precedent. Accordingly, your learning intention for this video is that you should be able to discuss how the doctrine of precedent affects the ability of courts to make law. Make sure that you write this learning intention down in your Cornell notes. As you know, both Parliament and courts make law. The laws that Parliament makes are called statutes, acts of Parliament, or legislation. The primary role of Parliament is to make laws. Courts also make law. The law that courts make is called common law, also known as case law or judge-made law. Courts can make law when they decide a case. However, unlike Parliament, the primary role of the courts is not to make law. Instead, the primary role of the courts is to decide, that is, to resolve disputes by applying existing law to the facts of the case that they are hearing. However, in the course of hearing a case, that is, in the course of resolving a dispute, a judge can make law. That is, a judge can make law when a case is brought by a party to the court and that case raises a legal issue that needs to be decided by the judge in order to decide the case. This is why we say that the role of the courts in making law is a secondary role of the courts. They only do this as part of their primary role, which is to resolve disputes. The courts make law in 2 ways. The first way in which the courts make law is when they create or modify a precedent, because the case that they are hearing is not covered by an existing precedent. An existing precedent is a law that has been made by a previous court decision. The second way in which the courts make law is by interpreting a statute, that is, a law made by Parliament. A court may need to apply a statute to decide a case that they are hearing, and this may mean that the court must interpret or give meaning to words in that statute. One of the effects of a court interpreting the words in a statute is that the court may create a precedent as to the meaning of those words. This precedent will be binding on lower courts in the same court hierarchy when those lower courts are interpreting those words in the statute. And this precedent will be a persuasive precedent for other courts, for example, higher courts in the same court hierarchy or courts in other court hierarchies when those other courts are interpreting similar words. In making law, a judge will be guided by the doctrine or rules of precedent. A previous court decision may have created a precedent that is binding on the judge, that is, that the judge must apply. This will be the case where, first, the judge is a judge in a court that is in the same court hierarchy as the court that made the precedent, but that court is lower than the court that made the precedent. And second, where the material facts of the case in which the precedent was set and of the case that the judge is deciding are the same. Even if a judge is not bound by a particular precedent, the judge may choose to follow that precedent which has been set by another court because the judge agrees with that precedent. That is, the judge may choose to follow a persuasive precedent. The doctrine of precedent has two main advantages. First, the doctrine of precedent creates consistency. This means that similar cases are decided in a similar manner. Second, the doctrine of precedent creates predictability. That is, if a case is similar to a case that has set a precedent, then the lawyers for the parties are able to advise their parties that the new case is likely to be decided in accordance with the precedent that has already been established. This means that the parties are able to avoid the expense and time of fighting the court case where the issue has already been decided in a previous court case. So, in that kind of a situation, the parties are more likely to try to settle their dispute without going to a court. And in settling their dispute, they will presumably settle it in accordance with the previously established precedent. Before we look specifically at how the doctrine of precedent affects the ability of the courts to make law, it's worthwhile considering some general strengths and weaknesses of the courts as lawmakers. Please include this table in your summary books, and as you listen to the discussion which follows, make such additional notes on this table as you think will help you to better explain the points that this table makes. The first strength of the courts as lawmakers is that judges are independent and impartial decision makers. This means that judges will decide the cases that they hear by applying the applicable legal principles in an unbiased way. The second strength of the courts as lawmakers is that the courts may declare a law made by Parliament to be invalid if Parliament does not have the power to make that law, for example, because the law breaches the Constitution. In such a case, we say that the law is ultra vires, that is, it is outside the power of Parliament to make the law. The power of the courts to declare a law made by Parliament to be invalid where Parliament doesn't have the power to make that law is an important power of the courts because it protects individuals from Parliament abusing its lawmaking powers by making laws that Parliament has no power to make. On the other hand, the courts have a number of weaknesses as lawmakers. First, because judges aren't elected, they might make laws that don't represent community views and values. This is very different from Parliament, where the members of Parliament are elected by the people, and so they can be voted out by the people at an election if the people don't agree with the laws that Parliament is making. Second, as I've explained, judges can only make a law about an issue if a case raising that issue has been brought to the court. A case can only be brought to court by a person who has standing, that is, by a person who is directly affected by the legal issue that is raised by the case. In addition to standing, a party can only bring a case to court if that party has the time and money to bring that case. Put another way, if no party with standing, time and money brings a case to court, then the court cannot make law. Again, this is a difference from Parliament. Parliament can make a law at any time while Parliament is sitting, and Parliament can make a law about any matter that is within its lawmaking powers. And third, because Parliament is the supreme lawmaker, it can abrogate, that is overturn, a law made by the courts where Parliament disagrees with that law. Parliament will do this by passing legislation that overturns the court-made law. The only exception to Parliament's supremacy is that Parliament can't abrogate the High Court's interpretation of words in the Constitution. As you'll recall, our learning intention for this video is that you should be able to discuss how the doctrine of precedent affects the ability of courts to make law. The table on this slide and the next slide sets out in the left-hand column how the doctrine of precedent contributes to the ability of the courts to make law, and in the right-hand column how the doctrine of precedent detracts from the ability of the courts to make law. Please include this table in your summary books, and as you listen to the discussion which follows, make such additional notes on the table as you think will help you to better explain the points made in the table. The first way in which the doctrine of precedent contributes to the ability of the courts to make law is that the principle of stare decisis, that is, that lower courts in the same court hierarchy must follow the reasons for the decisions of higher courts in the court hierarchy, that principle results in consistency and predictability. As I've explained, consistency means that like cases are decided in a like manner, so parties are treated fairly. And predictability means that the parties, or at least their lawyers, can predict the outcome of a case based on previous court decisions. If parties can predict the likely outcome of their case, then they can avoid wasting money and time on taking their case to court, and instead they can negotiate a settlement of the case, presumably in line with the way in which the previous cases have been decided. In particular, predictability means that a party can avoid wasting money and time on taking a case to court where that case is unlikely to succeed. In addition, judges are legal experts, and so the precedents that they make should be sensible and appropriate laws. Moreover, precedents made by judges provide guidance to other judges in deciding similar cases. This avoids a judge wasting the time and money of the parties by reconsidering issues that have already been decided by a judge in a higher court. In other words, the judge doesn't have to reinvent the wheel because a judge in a previous case has thoroughly considered the legal issues and come up with an appropriate legal rule in the form of a precedent. So you can see that the doctrine of precedent does help courts to make law by providing well-considered legal rules that ensure consistency and predictability and that guide judges in deciding future cases. On the other hand, it can be difficult and time-consuming to work out what precedents apply to a particular case. This can also be expensive for the parties because they will have to pay a lawyer to advise them what the applicable precedents are. There are a number of reasons that it might be difficult to find what the applicable precedents for a case are. First, there may be a large number of cases that need to be considered by both the judge and the parties' lawyers as they try to work out what the applicable precedents are. This is because a precedent is often developed and refined over a number of cases. As I explained in the precedent refresher video, the law of negligence was developed over 100 years as cases came before the courts, and in fact, it is still being developed as new cases come before the courts. The judgments in all of these cases have contributed to the gradual development of the law of negligence, and so to fully understand the law of negligence, it's necessary to read a large number of court cases. The second reason it can be difficult to work out what precedents apply to a particular case is that when a judge writes a judgment, the reasons for the judge's decision, that is, the ratio decidendi of the decision, which is what forms the precedent, these reasons may be spread throughout the judgment as opposed to being found in one place. It would certainly be nice if judges had a section in their judgment that concisely summarised the reasons for their decision, but that's not often the case. The third reason it can be difficult to work out what precedents apply to a particular case is that precedents are often set by courts on appeal. This is because a party can generally appeal to a higher court to review a decision made by a lower court on the ground that the lower court has misapplied the law. In such a case, the higher court will have to decide what the correct principle of law is. In deciding what the correct principle of law is, the appeal court might create a precedent. Where a court hears an appeal, there will generally be more than one judge who sits on the court to hear that appeal. For example, when the High Court hears an appeal, it is usual for all 7 judges of the High Court to hear the appeal. In such a case, unless all the judges hearing the appeal are able to agree on a single set of reasons, the judges might write separate judgments. And some judges might decide in favour of the appellant, while other judges might decide in favour of the respondent. Where more than one judge hears a case, the party that succeeds will be the party who the majority of the judges agree should win the case. The precedent set by the appeal court will be made up of the reasons of this majority of judges to the extent that those reasons are the same. That is, the precedent will be made up of the common reasons of the majority of the judges hearing that case. Some time ago, there was a fairly famous case decided by the High Court which related to the interpretation of the Commonwealth's GST, that is Goods and Services Tax, legislation. Each of the 7 judges on the High Court wrote a separate judgment. While a majority of the 7 judges agreed on the outcome of the case, they each had quite different reasons for that outcome. This made it really difficult to work out what the precedent set by that case was. Even the judges had difficulty working it out because they had each given different reasons. In the end, the judges had to write a summary that set out the precedent of the case, based on the reasons that were common as between their judgments. So, you can see that if experts like High Court judges sometimes find it difficult to work out the precedent that has been established by their own decisions, other judges and lawyers are also going to find this to be difficult where the precedent has to be found from different judgments given in the same case. The fourth reason it can be difficult to work out what precedents apply to a particular case is sometimes there may be conflicting precedents. That is, precedents that are inconsistent with one another. This is because precedents are developed as courts decide cases, and sometimes a judge might decide a case without being aware of what another judge has decided in a similar case. Or perhaps the judge disagrees with what another judge has decided in an earlier case. Where there are conflicting precedents, the lawyers for the parties and the judge will need to work out what the correct precedent is. The second way in which the doctrine of precedent contributes to the ability of the courts to make law is that even though it requires courts to follow precedents that are binding on them, it does give the courts some flexibility when they are making law. In particular, as we've seen from the precedent refresher video, a lower court which is bound by a precedent that has been set by a higher court in the same court hierarchy may be able to avoid applying that binding precedent in 3 circumstances. First, if the lower court can distinguish the precedent because the material facts of the case that set the precedent and of the case that the lower court is hearing are different. Second, the precedent may have been reversed by a higher court on appeal, in which case the lower court is bound by the precedent set by the appeal court and is not bound by the precedent set by the court whose decision was appealed. Third, the precedent may have been overruled by a higher court in a later case, in which case the lower court is bound by the precedent set by the higher court and is not bound by the overruled precedent. However, there are some limitations on the flexibility of the doctrine of precedent, particularly when it comes to a court overruling a precedent. Firstly, while it is possible for a higher court to overrule an earlier precedent, a court may be reluctant to overrule a long-standing precedent because the court could be concerned that this will create unfairness. For example, in Trigwell's case, the High Court refused to overrule a long-standing precedent that a farmer was not liable for loss caused by the farmer's stock straying onto the road, for instance, as where the stock caused a car crash. This precedent was established more than 100 years ago, before we had highways and cars, but the High Court was concerned that if it overruled this precedent, then this could cause uncertainty and unfairness because farmers had taken decisions based on this precedent, including decisions about whether and how to fence their stock in paddocks. If the farmers had known that they would be liable for their stock straying onto the road, then they would presumably have built stronger fences. A court might also be reluctant to overrule precedents that it has established in previous decisions. As you'll recall, a court is not bound by a precedent that is set by that court in an earlier decision. Such a precedent is only a persuasive precedent for the court. It's not a binding precedent because the precedent has not been set by a higher court. Nonetheless, courts are often reluctant to overrule their previous decisions, that is, precedents established in previous cases, because this reduces consistency and predictability. And finally, even if a court is prepared to overrule a precedent, it can't do that unless a case challenging the precedent is brought to the court. And, as you know, a case can only be brought to a court by a party that has standing, that is, by a party that is directly affected by the precedent. And that party must also have the money and time to bring that case to the court. If no party with standing, time and money is prepared to bring the case to the court, then the court will not be able to overrule the precedent. The other way in which the doctrine of precedent isn't very flexible is that unless a lower court can avoid a precedent that would otherwise be binding on it, for example by distinguishing the precedent because the material facts of the two cases are different, then the lower court must decide its case by applying the binding precedent. This is so even if the precedent is outdated and even if the application of the precedent will lead to an unjust result. The lower court can disapprove of the precedent, that is, it can state that it disagrees with the precedent, but it must still apply the precedent. The only way that a party can have the precedent overturned is if the party appeals from the lower court's decision to a higher court, and that higher court overrules the precedent and reverses the lower court's decision. However, it's expensive and time-consuming for a party to appeal a lower court's decision to a higher court, and this can be a barrier to an appeal. Finally, a major limitation on the ability of the courts to make law is that a court cannot create a precedent, that is, a court cannot make law unless a case is brought before the court, and that case requires the judge to create a precedent to decide the case. A case can only be brought to a court by a party that has standing, that is, by a party that is directly affected by the legal issue that the case raises. And that party must also have the money and time to bring that case. If no party with standing, time and money is prepared to bring the case, then the court will not be able to make the precedent. That is, the court will not be able to make law. Well, that brings us to the end of this video. As a result of watching and taking notes on this video, you should now be able to discuss how the doctrine of precedent affects the ability of courts to make law. Please now read the pages from the textbook referred to on the first slide, and if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that additional information. Thank you for your attention.